Before we start, I wish to inform participants that all sessions of this SIEL conference, including this particular one, will be recorded, and the purpose of the recording is to make the videos available on the platform for the registered delegate for around 2 weeks. So this is the announcement. Now, let me start by greeting you from Geneva. My name is Chang-fa. It is my real honor to welcome you to the panel, panel 13, on the future of international economic governance. I trust you share with me that there are so many new development, perhaps exciting development, factors or even events in recent time to force us to reflect whether the current international economic governance is sufficient or efficient enough to respond to them, whether this is the time to change the mode or the operation of international governance, and if it is the time for us to change, and what would be the direction we need to move toward, and what would be the specific changes we need to make. Examples of new development that we need to reflect are the digital economy, the state capitalism-related subsidies. Examples of new factors that we need to address are the deterioration of fisheries resources and deteriorating environment. Examples of new events that we need to tackle are the COVID-19 pandemic and the related public health and economic impact. Unfortunately, as everybody knows well, the WTO has not been able to update its rulebook to cope with the new development for decades. And the WTO has sponsored fisheries negotiations for 20 years, and the negotiation is yet to come to a conclusion. And the WTO members are still struggling with and debating on what would be the appropriate way to save people's life and livelihood, which have been gravely endangered by the pandemic. However, we have no right to be pessimistic. We hope there will be real progress in WTO negotiations on the above issues. What we should be particularly optimistic is that we have scholars devoting their greatest effort to push government and international organizations to move forward. In our session, we will see what our speakers can help us to think and to help make international economic governance better. We are pleased to have excellent panelists to address various aspects of international economic governance. Professor Thomas Streinz is Executive Director of NYU Law. Mr. Klaus Günter is International Relations Officer of the European Commission. Professor Wentong Chen is University of Florida Research Foundation Professor at the University of Florida College of Law. Ms. Yaxuan Chen is Senior Consultant at the Economic and Trade Policy Unit of UNEP. Thomas is to address shifting paradigm in international economic law, and Klaus is to address sustainable transformation of global economic governance. Both of them are exciting topics. And of course, another two excellent topics include Wentong's
micro, it's muted.
Hi, Chang-fa, we couldn't hear you anymore.
What happened? Is it okay now?
Yeah.
Sorry, my apology. Thomas is to address the shifting paradigm, and Klaus is to address sustainable transformation. Wentong is to address subsidies reform, and Yaxuan is to address transparency reform under the WTO. So we have two speakers addressing some broader and overall governance issues, and two other speakers covering specific issues. And their backgrounds and topics are complementary to each other. And we have perfect combination in our session. We thank them for joining this session. I'm going to conduct this session in an interview format so that we can enjoy listening their viewpoints on an issue-by-issue basis. We will then see how much time remained for us to have further interaction among the panelists and with the audience. If I may, let me start with Thomas, who is going to address the shifting paradigm in international economic law. Let me start with an interesting term, the mega regulation, which is, I think, created by you and your co-authors in a separate paper. Can you explain what does it mean by mega regulation, and how does the idea of mega regulation work for and affect the current international regulatory regime? Thomas?
Yeah, thanks a lot to SIEL for putting this panel together, and to you for tuning in, and to my co-panelists and our chair for conducting this in this exciting interactive interview format. So on mega regulation, it's of course a very fancy term that is supposed to attract academic and maybe even practitioner and policymaker interest, that we coined in our mega reg project at NYU School of Law, Institute for International Law and Justice, mainly with my co-conspirators in mega reg, Benedict Kingsbury, Richard Stewart, and Paul Mertenskötter. And we started this project at a time where mega regional agreements were very much on vogue. So there were the negotiations between the EU and the US on the transatlantic trade and investment agreement, and there were negotiations in the Asia-Pacific region for a Trans-Pacific Partnership. And since the TTIP didn't go anywhere, we ended up focusing on the TPP, which, as all of you will know, also had a quite tumultuous fate, getting tanked by the Trump administration and then resurrected by the remaining 11 parties as the CPTPP. And what we tried to understand was whether there's anything distinctive about TPP. And many have pointed out that it's a very large agreement that could call a mega regional agreement, but we thought that there was something more to it. And this something more, this something special, we tried to describe with this term mega regulation. So mega regulation is supposed to describe a certain form of global economic ordering that will seem very natural to trade lawyers, very natural to experts of international economic law and international economic governance, just a continuation of free trade agreements that get deeper and more comprehensive. But once you zoom out and once you compare TPP and CPTPP to other forms of global economic governance, you see that it's actually quite distinctive. So yes, its scope is very broad, but it's not really about traditional trade. It's about all kinds of flows that are supposed to flow through this mega region, not necessarily between national economies, but within firms within that region. And the goal is for globally operating companies to have what we call a generalized freedom to operate. And to achieve that, it's long been a goal in international economic governance to harmonize and to create some kind of convergence of regulatory systems. And we believe that what TPP does is a little bit different from other agreements in placing less emphasis on harmonization and mutual recognition and much more on domestic regulatory governance, creating procedural obligations that allow companies to push through the domestic settings for more harmonized regulatory rules, creating a kind of regulatory alignment that then exists not just within the TPP mega region, but beyond, because the large scale of these agreements pulls others into that zone, so that a regulatory rule that gets shaped within TPP under the pressure that can be exercised through the procedures might spill over into other regions and neighboring countries. And finally, for trade lawyers, it's of course natural that this is a treaty under international law, but once you compare TPP to other large-scale ordering projects like the Belt and Road Initiative or to internet governance, you see that a treaty is not always the norm. And in that regard, it's distinctive that TPP creates rules for issues such as free data flows. So all of these features we try to put together under this fancy term, mega regulation.
Thank you. This is an extremely interesting finding. The new approach that you are able to identify from the CTPTT and the implication for other FTAs or regulatory regimes. So turning it back to the current paper that you are presenting at this conference, you also create different set of terms that might be related to the idea or the concept of mega regulation that are the standard paradigm. If I understand correctly, you refer to the so-called traditional paradigm, as opposed to the concept of new paradigm in international economic law. So what do you mean by standard paradigm, and what are the problems with the standard paradigm that you're trying to deal with?
Yes, thanks a lot. So this new project, which is a joint project with my MegaRec colleague, Paul Mertensgötter, even though I'm solely responsible for everything I'm saying on this recorded session, is a reflection on our MegaRec project, because we realized afterwards that we came to see international economic law differently. And he did that in his PhD work on how global corporations are able to mobilize instruments of international economic law to push against food labeling requirements. And I came to realize in my work on international economic data governance that international economic law works differently in those domains, and that we, through the MegaReg project and through this conceptualization of mega regulation as an explanation of what happened in TPP and CPTPP, came to become more critical of a more traditional way of understanding international economic law. So this new project is not an attack on the traditional way, but it's a reflection on how I personally, as an international economic lawyer, have shifted from what I would call a traditional paradigm, where we understand international economic law as a discipline of international public law. So we mainly focused on states and international organizations as the traditional subjects of international law. And we are mainly concerned with their relationships as it develops through customs and treaties. And there's a certain alignment then between this conception of law, this traditional international public law conception of law, and how we conceive of the economy, where the economy is conceived as national economies that then trade with each other. And in these national economies, we have national firms that have offensive and defensive interests that get traded off each other. And so it's all about exports and imports from these and into these national economies. So that's the traditional paradigm. That's how we would understand the GATT system, maybe. And it can explain the GATT system to a very large extent, but it might not be able to explain more recent developments in international economic law and in international economic governance.
I see. So, you've mentioned a new paradigm. Can you explain a little bit further on what fact and element, including what you've mentioned about state to state versus some other new players? So, what fact or element have led you to suggest that this is so important for us to focus on or to be aware of the new paradigm, and how does it relate to the global value chain that you also mentioned in your paper?
Yes, so thanks a lot. So for international trade lawyers, there's always a temptation to focus on one of the crown jewels of the Uruguay around the creation of the dispute settlement system, the judicialization of international trade law. And we had a great panel on that yesterday. But international economic law works in other ways as well. And the new paradigm tries to make these new ways of global economic governance more visible. So one element of that I already mentioned in my explanation of mega regulation is what Paul Mertensgötter and Dick Stewart have called remote control, where it's possible for globally operating corporations to insert themselves into domestic rulemaking efforts, not just because they're powerful global corporations, but because international economic law has opened up this domestic rulemaking in the interest of creating more regulatory alignment. And Paul Mertensgötter's work with Tim Dorlach goes in a similar direction, showing how the food industry can suddenly intervene in Chile's efforts to create new food labeling requirements. And a lot of people and a lot of trade law experts will have always known this. The difference is to make it more visible, to shift the focus away from the dispute settlement and from the state-to-state interaction, and to get a more holistic picture of all the actors that are involved in global economic governance in practice. So that also involves the lawyers that are getting employed by corporations to advance arguments of international economic law, not just when it's about launching dispute settlement proceedings, whether of the state-to-state or of the investor-state variety, but earlier, when it comes to making arguments that suggest that a certain country should not adopt a restriction on cross-border data flows, for example. And so that's on the legal side. And on the economic side, it's just not true that we have trade between national economies. And economists, of course, long realized that under new trade theory, that a lot of trade, what we call trade, is not trade between countries. And it's not even trade between companies within countries. It's trade within companies. So the relevant actor is really the globally operating corporation that is able to construct global value chains through contracts on the private law side, but also because international economic law develops an infrastructure that enables that kind of global value chain to operate globally with reduced compliance costs and reduced barriers to trade.
Thank you. Very, very interesting. Suppose you are advising a policymaker of a particular country, or suppose you yourself are a negotiator participating in the formulation of the new rules or to address the new situations. What do you suggest the policymaker or the negotiator to perceive the new paradigm for the purpose of helping their work, helping them to understand the new perspective and to contribute to the international economic governance?
Yeah, thanks a lot for this practice-oriented question. And I don't envy the really hard and challenging tasks that practitioners and policymakers and trade negotiators have. I think there are potentials and pitfalls, possibilities and challenges here. I think the possibilities, if one adopts this more new paradigm-esque mindset, is to think more broadly about potential coalitions that can push us towards new rules. So to expand the horizon, to think more about transnationally, how coalitions of civil society actors or companies can push us in a direction of, for example, more sustainable trade. And I think if we look outside the trade context towards the ways in which the Paris Climate Change Agreement was designed and achieved, we can see how it worked in that context. And I don't see why it couldn't work in a similar way in the WTO if the WTO opened up a little bit more towards this kind of multi-stakeholder engagement. One big challenge I see is that it's very hard to assess the consequences of the kind of rules that are being created. And that's also a challenge that the WTO is now facing in the Joint Statement Initiative on e-commerce. And a sub-problem of that is that we don't have, paradoxically, very good data about the state of the global economy, especially about the digital economy. So everyone seems to agree that we need global data flows because of global value chains, or because otherwise we couldn't have a SIEL conference through this online platform. And that's, of course, true. But we don't actually have solid data that tells us about the realities of data flows. We have to use all kinds of proxies that don't really assess who benefits from the data flows that technology enables and that international economic law is asked to safeguard going forward. And that's particularly challenging then once as a policymaker that is responsible politically towards a government and towards the people of a country to say, is this good for us? And I think that also explains some of the hesitation, at least, that some countries that don't participate in the Joint Statement Initiative have about the effects that these kinds of rules will have on them going forward. So with that, I think there's a need, once one recognizes all these other actors, to also get them involved in trying to create a more solid data-driven basis for new rulemaking in international economic governance.
Mm-hmm. Well, I trust that there will be a need of changing some kind of mindset of the participants of international economic governance, and I believe you share with me that changing people's mindset is extremely difficult.
Absolutely.
Thank you so much. Thank you so much for this extremely interesting findings and arguments. And I believe people need to really sit down to reflect on so much new ideas so as to really cope with the new development. Thank you so much, Thomas. Now, if I may, I'd like to turn to Klaus. Klaus' paper is about sustainable transformation of global economic governance, and the paper covers so much important element of the need of addressing the sustainability aspect. So, Klaus, let me start by asking you about your paper, which mentions that the COVID-19 pandemic is a wake-up call for us to reconsider the adequacy of current global economic governance. What have you found the system's deficiency under the current global economic governance?
Thank you very much for this question. Good afternoon. Well, let me start with a disclaimer that I have to make. I am speaking here in my private capacity, so nothing that I say here can in any way commit the European Commission or be interpreted as a viewpoint of being in the interest of the European Commission. Having said that, nevertheless, my reply to your first question might give a bit of context to some initiatives that the European Commission has recently taken or is about to take in the context of climate change or sustainable development. The pandemic, as we all know, has become an extremely challenging public health emergency for people, societies, and economies across the globe. In terms of fatalities, the coronavirus is the most significant event since World War II. In economic terms, the pandemic has resulted in significant global social and economic disruption, including arguably the largest global recession since the Great Depression. The IMF estimates that the global economy shrunk by 4.4% in 2020. So the spread of the virus has disrupted global supply chains. It has caused pronounced volatility in financial markets. It has created consumer demand shocks. It has had a wide array of impacts in critical sectors such as transportation and tourism. The measures that were put in place to contain COVID-19 could hinder the supply of critical products and affect output. Sorry, I have to hear really well, or is there something? I hear a sound. Perhaps if you, sorry, mute. Yeah. So, in fact, as a matter of fact, the current global economic governance was not able to prevent this scenario from happening. The pandemic has highlighted the interconnected nature of economies, which rely on stable and predictable international rules and resilient transportation channels. However, these rules have proved insufficient to trigger the necessary collective action, such as expanding international health cooperation, avoiding or lifting export restrictions on critical medicines, ending the destruction of supply chains, or ensuring the fast disbursement of relevant medicines and eventually a vaccine. And in particular, the pandemic has made the attainment of the 17 Sustainable Development Goals, upon which all UN members have agreed, more difficult. The Sustainable Development Goals report of 2020 illustrates in that respect that even before the pandemic, the world was already off track in respect of the great majority of the SDGs, such as ending poverty and food insecurity, inclusive and equitable quality education, safely managed drinking water, and so on. And in particular, climate change and environmental degradation continue apace. the UN's latest Global Environmental Outlook 2018 reports a rapid deterioration of environment in all regions. As regards climate change, according to the UNEP emissions gap report of 2019, if we rely only on the current climate commitments of the parties to the Paris Agreement, temperatures can be expected to rise by 3.2% still this century. And a 7.6% emissions reduction every year between 2020 and 2030 would be needed to limit global warming to 1.5% as envisaged in the agreement. Now, here is the dilemma or the irony. The reduced economic activity worldwide due to the COVID-19 pandemic, which was one of the worst recessions in a century, caused a 6 to 7% drop in greenhouse gas emissions for 2020. So the greenhouse gas emission reduction caused by this, one of the greatest recessions, was not enough to limit global warming to 1.5% if the scientific indications are right. And this gives a hint at what building back greener and carbon neutrality will eventually have to entail if the goal of limiting global warming to 1.5% is taken seriously. That means the inconvenient truth is that the economic and social fabric of the world economy will come under sustained and increasing stress. And global economic governance will have to provide an adequate framework to manage that process sustainably and peacefully. The reactions to the pandemic, however, suggest that so far it is not up to this task. Also, combating the effects of the pandemic has led to a significant increase in government support and involvement in the economy. The large amount of liquidity which has been introduced into the market can either reinforce the carbon lock-in effect by investing in the carbon-intensive sectors, or go to clean energy sectors to escape the path dependencies of fossil fuel-based production and consumption. The impact of the fiscal stimulus plans for the recovery on global warming will depend very crucially on how they are designed and used, which means whether they promote investing in carbon-intensive sectors or clean energy sectors. And here again, global economic governance is called upon to provide the necessary framework for an adequate outcome. Thanks. You're muted. I cannot hear you.
Is it on now?
Yes.
Yeah. Thank you so much. I think you mentioned a number of extremely important issues that we are now facing. Public health crisis, climate crisis, all of them are so important. And of course, these are all economic or even trade related. So my next question has to do with how and to what extent do you consider the current economic governance, including the WTO, governance under the WTO, could cope with all these non-trade but trade-related issues? They are so important and so broad. And now, as everybody knows well, WTO is now debating on how to address the COVID-19 issues, the trade aspect, and there are so many different views, and it is extremely difficult for people to come up with a consensus to say, well, this is the perfect way of addressing this. So this is a big challenge to the current WTO, current international economic governance. So what do you see, how do you see that, what should be included so as to still make the organization working, not being overloading, and still be contributing?
Well, I must confess, I do not have the magic solution on this, but I think nobody so far
Difficult,
has.
yes.
All I can say is what is quite evident that global coordination at all levels will be needed to cope with these non-trade but trade-related issues, and in particular to reach the UN SDGs and combat climate change. And here, functioning multilateral institutions are a key collective global good that are indispensable. Well, in this respect, they are an essential prerequisite for coping with these challenges, and in particular, the rules-based multilateral trading system of the WTO, which is a cornerstone of global economic governance. And in fact, sustainable development is already mentioned in the preamble of the WTO agreement, and indeed the WTO has already contributed to global sustainable development in the last decades since its entry into existence. Its economic openness has helped integrate many developing countries into the world economy and has lifted hundreds of millions of people out of poverty and decreased inequalities between the countries. Now, at this stage, WTO members should realize that the green transition of the economy to economic, ecological, and social sustainability is a necessity, not just in the medium term, but now, because it already constitutes smart economic policy today for all WTO members, regardless of their level of development, of their political or ideological affiliation, since it is the only viable policy in the long term. The ecological limits of the planet are not negotiable. And if we act otherwise, we risk pushing the planet beyond its tipping point in the near future. And this green transition is in particular also warranted from the perspective of transgenerational climate justice.
Thank you.
Multilateral trade policy with the UN SDG objectives could in particular also offer a sense of common purpose and rebuild trust among the membership. And what would help in particular would be a common understanding among WTO members on basic sustainability standards that can legitimately be adopted to promote objectives that address common concerns of humankind, such as climate change and biodiversity loss. Such a multilateral approach or understanding would arguably also be a good mechanism to forestall the instances or reproaches of green protectionism or greenwashing. Idealistically, WTO members could even agree that the WTO rules recognize the right and preferably even the obligation of members to provide effective responses to global environmental challenges. Steps in this direction are there. There's the communication on trade and environmental sustainability, sponsored by 50 WTO members. There is the Commission non-paper of October 2020 on a possible trade and climate initiative, and there is the prospect of an agreement at MC12, the ministerial conference this year, to reinvigorate WTO work on trade and environment in view of mainstreaming sustainability issues in the WTO work. Perhaps just very briefly on substance, conclusion of the fisheries subsidies negotiations and addressing trade and health issues would evidently boost the WTO's credibility. In agriculture, of course, discussions focus on equitable commitments on domestic support or support reduction, but moreover, harmonized rules which allow for measures or even encourage measures to ensure sustainable food security in the face of climate change and biodiversity loss would also be desirable. For instance, reduction of pesticides, fertilizers, antimicrobials, promoting environmentally friendly value chains, or reducing environmental pollution and preserving biodiversity. Overall, the cooperation among the WTO and multilateral environmental agreements, institutions should be strengthened, and we should use the UN Decade on Ecosystem Restoration 2021 to 30 to make progress in respect of all these aforementioned elements and create the foundations for strong, sustainable, and effective global economic governance. Thanks.
Thank you so much. I couldn't stop thinking of asking you more questions, but I'll come back to you if we still have time on a number of interesting questions arising from your paper. If you allow me, let me turn to Wentong. He is presenting his paper on subsidies regime under the WTO. New regime is the title of his paper. And another very interesting term is the twin capitalism. So the market capitalism and the state capitalism being considered as twin capitalism. Wentong, can you explain their respective meanings for us?
Well, thank you, Chang-fa, for giving me this opportunity to present my paper with Professor Sungjoon of Chicago-Kent College of Law. I guess there are no formal definitions of market capitalism and state capitalism, but the term market capitalism generally refers to market economy where the resource allocation is being done primarily by the market forces of supply and demand. Whereas state capitalism refers to the economy in which the government plays a dominant role in resource allocation through the use of industrial policy and subsidies, and so on. So a central point that we are making in our paper is there is really a continuum of the different types in the real economy. We don't really see a stark contrast between what we call market capitalism and what we call state capitalism. The degree of state intervention in both types is really a continuum. It's not a black and white thing, right? So the difference between market and state capitalism in terms of state intervention is really, they differ really only in degree, not in kind. So unfortunately, what we have seen so far in the last several years, at least, is much of the trade relations is being politicized along this, fictional divide between market and state capitalism. So that's a central point that we're trying to make. It's sort of a myth to talk about two different, very, very different types of capitalism. They are really twins.
Thank you so much. In arguing the relations between market capitalism and state capitalism, you elaborate some background, which include the politicization, sorry for the pronunciation, of trade relations, which you consider having undermined the global economic governance system under the WTO. Can you elaborate a little bit more? What are the facts or actual events which shows that the international trade relations have been politicized? And if there is the politicizing of the situation, is it the new phenomenon, or is it always the situation which is only recurring in the recent years?
We would say the politicization of trade relations is not a new phenomenon. It has been a recurring phenomenon. It is one of the undercurrents within the world trade system, right? So there was a long-standing struggle between the so-called power-based trade relations and rule-based trade relations. I think one of the central goals of having the GATT and the WTO is to move away from this power-based system, to use Professor Jackson's term. So in the 1980s, we had this politicization of trade relations between the Western nations, well, maybe Western nations is the wrong term, but between the US and Europe and Japan, right? So there we had pretty politicized trade relations, but that politicization subsided, after Japan, the rise of Japan was blunted, right, by all of those different factors, including the Plaza Agreement. But I think one of the most defining moments of the politicization of trade relations was the U.S.-China trade war, between 2017 and 2020, and some say it is still going on. China was being singled out for a practice or for practices that are pretty common among all trading nations. China may be pushing the practice, it may be pushing a little extreme. The subsidies, the industrial policies that are being used by China are pretty much, they are more severe, but we wouldn't say is an outlier. Many nations, including the U.S. and Europe, they do subsidies, right? They do use industrial policy, although to a lesser degree. But China is being singled out for that, for those issues, and more importantly, it is being dealt with not within the multilateral framework. Instead, people are resorting to unilateral measures like Section 301. Okay, so they are doing that outside of the WTO framework. So that's what we mean by politicization of trade relations. So it's definitely not a new thing, but is reaching a new height in the last several years.
Thank you. Thank you so much. Well, let's now turn to the core part of your paper, that is about subsidies. You argue that the WTO subsidies rules need to be updated. And what are the aspects you consider in the subsidies rules that need to be updated, and how should they be updated?
So yeah, thank you. That's right. So the core arguments of our article is that we need to update all of the subsidy rules of the WTO. Well, from its inception, the subsidy regime of the WTO suffers from many imperfections, we should say. One of the central questions that the WTO members were struggling even before they signed up, when they were doing the Euro-round negotiations, was how do we define a countervailable subsidy, right? What is really a subsidy that should be illegal? So there we had a debate between should we discipline a subsidy that only has adverse trade effects on trading partners or not, right? Or even if a subsidy is within the meaning of the subsidy under the SCM agreement, should we make that subsidy not actionable or not? Right, based on their maybe benign effect on the economy or social developments, like we had a research and development subsidy. So those are all of those kind of non-actionable subsidy issues. So I think we haven't really sorted out all of those answers. Now there are some recent newer issues. Especially in the last decade or so, when all of those hybrid economies started, subsidizing, right? So how do we deal with the so-called public body issue? In order to be countervailable, a subsidy has to be conferred upon a recipient by a public body, but does a state-owned enterprise constitute a public body or not? Does a state-owned commercial bank constitute a public body or not? Now, this is not only a China issue. We had the same question in other economies as well. Also, another question is the cross-border benchmark question, which we haven't included in our paper, but we're going to update our paper to include that issue. Under what circumstances can economies can the country that is imposing countervailing duties use benchmarks from outside of the exporting country? We had this question in the softwood lumber dispute, right, between the U.S. and Canada. But more importantly, we had the same issue in the U.S.-China subsidy disputes. And also finally, with the rise of the global value chains, we have to deal with the upstream subsidies that occur in a different country, the so-called transnational subsidies. So those are both long-standing and emerging subsidy issues that we really haven't come up with answers to. So that's why we need to work on updating the WTO subsidy regime. Now, to answer your second part of your question, how do we update them? One of the central points that we are making in our article is that we cannot rely on adversarial litigation to update the rules. So we need a discursive forum that we call a subsidy community or SCM community. So it can be you can use the platform. You can use the SCM committee as the platform, but it's definitely more than the SCM committee. So all the WTO members need to come together and figure out the solutions to those issues. And we should not, try to find solutions along geopolitical or ideological lines. We should, take up those specific subsidy concerns, right, and try to figure out a solution.
Thank you so much. Well, I fully agree with you that we cannot just rely on dispute settlement procedure to resolve the very fundamental and overall legislative issues. The issues that the substantive issues that you just mentioned are all important and difficult for us to resolve. That is why we cannot come to any real conclusion or even direction to address all these issues. Very interestingly, your approach is more from the perspective issue, not just expecting to modify the current WTO rules, but to create some kind of opportunities or environment for members to sit down to address these issues. Very specifically, you mentioned about the about having a mechanism similar to other WTO committees or subcommittees to allow members to raise specific trade concerns. And in your paper, you suggested that specific subsidy concerns may be raised in some kind of platform so that discussions can be conducted and possible solutions can be found. My question to you is that currently in many WTO committees, the raise of specific trade concerns are not leading to very successful or efficient resolution of the issues. Many of the issues have been on the agenda for such a long time and repeated once and again and not having any solution. So how do you see having a similar mechanism to allow specific subsidies concern being raised and we can expect that members will exercise their goodwill so as to resolve the issues more effectively? Can you give us some some inspiration about the possibility of having such mechanism to resolve at least some or part of the issues?
Well, thank you. That's a very important question, Chang-fa. You're right. Not every committee of the WTO is created equal. Some committees are rather successful, like the TBT committee and the SPS committee, as we flagged in our paper. Some committees are not successful. So I guess what we are proposing in our article is that having a discursive forum, having a subsidy community is a necessary but probably not a sufficient condition for success. So we have to have a process where we build consensus, right? But having a process where we build consensus may not guarantee success, but that's the only way to to success, to avoid being obsolete in the globalized era. So we probably need to dig a little deeper into the TBT and SPS committee to understand what makes those committees more successful than others. Maybe it has something to do with the nature of the subject matter. So maybe the subject matters are more technical than others. But that's the goal of our efforts. We need to move in that direction. We need to move away from adversarial litigation. So that's the point that we're trying to make. You're absolutely correct. We are not saying that we are guaranteed to have success if we move down this path. We are saying this is the only way that we can have, we can possibly have success. Now, maybe this is a perfect segue into my answers to your mega regulation question, if you don't mind. So as you said in your mega regulation question, we have been, the WTO process has long been member-driven, consensus-driven, but it has not been able to solve many of the most important issues. So what should we do? Where do we start? Well, I agree with your assessment. The member-driven, consensus-driven process is not serving us very well. But that's an unfortunate reality. We cannot, rush to do something just for the sake of doing something. The consequence of that mentality is what happened in the last decade or so. The blossoming of all of those different regional approaches, right? We have RCEP, or TPP, or the succeeding that. What is it called? CT, TPP. All those different approaches, all those regional approaches. All those regional approaches lead to the further fragmentalization of trade relations, right? So it's not healthy for a globalized world. So you're right. We don't really know how to move forward at this point, but I think it's more important for us to take a breath, to hold our breath, to not rush, right? To do something just for the sake of doing something. So I think a more long-term approach is to go back to the drawing board and build consensus through a gradual process. So it may not yield outcomes in the immediate terms, but it is going to be helpful for the long-term future of the world trade relationship.
Thank you so much. Definitely, we should not rush for any direction. Thank you so much for your new perspective. If I may, let me turn to Yaxuan. Yaxuan is dealing with the very important issue of transparency mechanism under the WTO. So my first question is to allow you to help us to understand why is the transparency requirement so important in the implementation of trade rules and even in the international economic governance. Yaxuan.
Okay, thank you. And thank you also for the opportunity to present the paper and this exchange. Also, quick disclaimer that all the views expressed here are just my personal views. And I have heard and noted that in the papers of the presenters and the questions here in the chat box, that everyone actually has touched on a little bit the topic of transparency. So at least in this panel, we all agree about the importance. But in short, when we look at the current transparency mechanism requirements and practice, no matter it's publication, notification, cross-notification, trade concerns, Q&A, TMR, or TPR, these requirements basically do two things. One is you get trade data and information of national trade policies into the multilateral forum in a classified and structured and commonly understandable manner, and then producing a multilateral feedback. So through consultation or multilateral deliberations at councils and committees, there could be a better multilateral understanding on the design and operation of the trade policies, their effect on international trade. And then this understanding form the basis of future interaction of parties and allowing the elaboration of the new norms. Meanwhile, this kind of a multilateral feedback in the form of concerns of peers expose actually the trade restrictiveness in the public. So it creates a pressure also for the removal of the trade barriers. When those intended functions are not fulfilled, then they are blind spots in evaluating trade policy trends and also for the implementation of global trade rules. And it could escalate the trade problems into disputes affecting the overall capacity and performance of negotiators. So as a result, and overall the credibility of the multilateral trading system suffers. But before I finish this one, meanwhile, I want to emphasize is we are now seeing new transparency challenges, as for example, mentioned by Klaus and also mentioned by Thomas. We would actually be at one point have to deal with the issues for supply chain transparency, for example. We are actually facing quite different requirements in terms of quality, quantity, and time-bound requirements regarding information. So it is very important actually for us to revisit the current design and to think about the future design. And then that will be the key actually for the future international economic governance. Thank you.
Thank you so much for the explanation. That is a very important background for us to appreciate your paper. Now, we understand the issue being so important. So tell us what are the current problem with transparency under the WTO that you have identified? Do you think the non-compliance is the result of the system itself? For instance, the system being unfriendly, or the system is lacking some kind of punishment or adverse results arising from non-compliance? What are the problems?
Okay, thank you. I think by asking this question and also this follow-up question, you seem to have identified the problem for me, being the lacking of compliance of notification obligations. So just a quick observation. So when we were at the global community at the Uruguay round, when this the policy, when this negotiation group on the functioning of gas system folks was established, the policymakers were complaining about the compliance with the notification obligations was incomplete and the system was fragmented. When you think about this statement, actually it's quite interchangeable nowadays. For example, it's roughly the same complaint you heard in the Goose Council that actually dealing with the transparency proposal that is featured with punishment measure. So the puzzle here is, what have we done in 30 years? We have invested tremendously in capacity building and technical assistance. We had improved the multilateral framework by introducing new information channels including cross notifications, specific trade concerns, also this TPR and TMR. So it basically allows formally, informally, this like a more proactive role for the secretary to fill in the information gap. And also it built the new channels of information, and then there are also activities to streamline and simplifying the procedure of notifications. And the idea of punishment is not that innovative. So meaning that the incentive, providing incentive is positive or negative for notifications had been discussed a bit already in the Doha round. So the fundamental question, I think, to ask as well is, what are members really concerned about? Lacking information or lacking compliance with notification? Are these two the same? I'm tempted to stop here and say, please read my paper for more details. But if you allow me for 1 minute. So when you think about the information provided through notification, if fully provided, then we will see that the trade policy data get classified and structured to describe what the measure is about. And then to some extent, analytical information would include it. For example, statistics, technical features, operations, and trade effect. Depends on the exact notification requirements. So reviewing the design and the practice of any other supplementary information channels that I just mentioned, you would find that members actually deliberately avoided generating complete information through those channels, especially for bringing in analytical information. So the whole transparency mechanism is actually centered around notifications, deemed that the measure imposers are the best information provider, especially in providing substantive analytical information analysis of trade measures. So this information were considered to be more authoritative. And so perhaps a prudent question is to understand the current transparency problem is whether this perception still holds true.
Thank you so much. Before I ask for the question, let me suggest that other speakers might want to check with the chat box so as to identify some questions that you might find extremely interesting, so as you would like to respond toward the end of our session. Very interesting point. In your paper, you also mentioned about modernization of transparency mechanism. This is a fancy term. Everybody needs likes modernization. But when I see this point, I cannot help but thinking of modernization with new technology, things like that. Does it relate to the use of technology to make it more user-friendly? If that it is the case, then how are we going to deal with the some developing country members which always consider that they are in lack of such necessary technology to be able to contribute or to fulfill their notification requirement?
Sure. So before I start to talk about modernization, maybe I should also explain why the current design is not modernized enough. I think everything here requires a bit understanding that the rationale behind the current design of a transparency mechanism was limited by the technology level, including the communications technology level, and the practice at the time when it was envisaged in the last century. So the value of new technology here is not just an efficiency tool. It's more about an behavior changer. In that context, so when we examine the transparency activities in WTO in recent 10 years, there are two features. There is increasing capacity of WTO members and the Secretariat to collect factual information of trade measures. And second, members do not necessarily take the accuracy of self-assessment of a notifier as granted. The driving force behind this include online publication of trade policy, rising recognition of the principle of open government data, accumulated knowledge of WTO members on each other's domestic governance structure and operations. So I want to cover also your question on developing countries very quickly. Is exactly a rationale change can only take place after everyone have access to the technology and is able to make behavior changes. Internet was born in 1960s, and the rise of cyber society took place in the 1990s. But 30 years later, taking the online presence of governments as example, and I only have the UN statistic now. So all the 193 UN member states are equipped with basic conditions of publishing policies and announcing governance changes online. This is, of course, relevant to years of investment in aid for trade, aid for development, capacity building by stakeholders inside and outside of WTO. I might not really have the time to cover the technical details on the proposed addition to WTO transparency mechanism, but by its essence, what I'm talking here as well is more automated information exchange to connect the dots that can provide raw data of trade measures and its factual description in a real-time manner. It does two things: provide timely information and truly convert trade data into assets for the global community. The application of technology here include big data, machine learning, legal technologies. But it actually is not like a fantasy because it has built on the emergent practice already, including this online publication, single window, construction of e-governance, and digital platforms for small medium enterprises, and efforts of data management and visualization of the WTO. So, and also as well as in other economic fields, including the rising of fintech. They are, of course, technology fix to allow for different like simultaneous data verification by WTO members to address potential political challenges on introducing such approach, especially on the fear of losing control over data interpretation. So what I'm proposing here also means that I'm proposing an infrastructure at the global level, which is supposed to actually reduce the burden of technology adoption using the resource burden and also the technology adoption burden for developing countries as well. Thank you.
Thank you so much. Thank you. This is very comprehensive. I think we only have 7 or 8 minutes left. My last question, and I want you to respond in connection or in addition to those you identify from the chat box, is about the what do we start? Everybody mentions about this need change. The other one, the other area is also important and needs change. And we understand that the WTO's legislative function is not very efficient. The fishery subsidies negotiation can continue for 20 years and haven't had a conclusion. So how do we start? And what are the most important for us to identify and to focus so as to come up with some real change in the foreseeable future? Of course, as Wentong mentioned, we shouldn't be rushing toward any direction, but at least we need to do something to start with. So if I may, each one might have 1 or at least at the most 1.5 minutes to be brief to respond to any question you would like from the chat box or from myself. Can I turn to Thomas?
Sure, thanks a lot. This has been a great panel, and I learned a lot from all of you, and also enjoyed the back and forth in the chat, which pushed me a little bit on the idea that this was a new paradigm in light of the fact that private actors have, of course, always been part of global economic governance and of the WTO system. What the paradigm shift tries to articulate is that there might be a need to foreground their role more and to make it indeed more transparent. Let me add to this a plug for my current work on quote-unquote digital trade, where I'm often in a position where I seem to make no one happy. Because my friends in internet governance and data privacy, they would argue that the WTO is not a legitimate venue to create rules for the digital economy at all. It should be the traditional, what they perceive to be the traditional venues for global internet governance, and venues that prioritize human rights and data privacy over economic interests in cross-border data flows. That's not my position. My position is that the WTO is right to address digital economy issues. But at the same time, I'm not convinced that the electronic commerce framing or even the digital trade framing that is now so much on vogue is the right framing for these issues, because it's not trade in the traditional sense. And you can see that in the provisions that you get in agreements like TPP that have nothing to do with goods or services trade in exchange of goods and services, but about data flows quite generally, as an enabler, as an infrastructure. And that's how we should talk about these issues in a more honest way. And that brings us into this tough position that was mentioned, that on the one hand, we need to identify priorities. And for me, priorities would be issues like data privacy, competition, taxation, and indeed sustainability and the fact of the digital economy on climate change. But at the same time, it's quite unrealistic that we will get consensus on these issues within the traditional WTO framework, which might suggest that we might need to adjust this framework to some extent, as I suggested earlier, to enable new coalitions. But it might also mean that the WTO might need to settle for a different set of rules that is less about consensus on the big picture issues and more about ensuring interoperability between different regimes that might emerge in regional settings. And I'll stop here, but I would love to continue this conversation later on with all of you on the panel in the audience. Thanks a lot.
Thanks a lot. We really need new settings to address the various novel issues. May I invite Klaus to say something? You are muted. I think you're muted.
Thank you. Well, as regards priorities, well, it's a very difficult question, perhaps. Distinction should be made between substance and procedure, and also perhaps between what would be desirable and what is possible in the short term. If we would apply the objective principle, first things first, then of course the physical survival of mankind, or in any event preservation of human civilization as we have known it in the last few millennia, should take precedence in combating climate change, biodiversity loss and environmental degradation. But here the dilemma seems to me twofold. First, we would have to determine who should contribute how much and when. So the thorny issue of climate and transgenerational justice. And second, how do we maintain social and political coherence when we implement the necessary transition and the necessary modification of citizens' lifestyles that entails. Now, in a way, coming back to reality, what is feasible in the short term? Here, I would definitely agree with Yaxuan that transparency as a possibility, a means of building trust and good faith is crucial and is indeed the best candidate for a possible outcome on the ministerial conference, the transministerial conference this year. Negotiations, deliberations, reflections are ongoing, as Yaxuan pointed out, in particular as regards to goods, perhaps even beyond. In the agricultural sector, we are actively reflecting on how to improve notifications and transparency with a view to enhancing the efficiency of work and bringing perhaps more dynamism to these long-standing negotiations on all aspects of the agricultural files. Perhaps on subsidies. Actually, I saw that there was a question, but it was asked to Wentong. But if I may, you know that there's a the notion of competitive neutrality is hovering around, and I could imagine that it might be viewed by some WTO members also with a bit of suspicion. But on the other hand, it tries to capture perceptions of a couple of indeed a couple of WTO members that something has to be done about how we treat in the WTO, and there are more or less concrete proposals on the table on having a new approach to industrial subsidies, perhaps introducing kind of boxes as in agriculture, red box, yellow box, green box. That might be a possibility, and in that respect, in that context, if it materializes, it could also even be used to introduce sustainable development aspects in constructing this green box and rewarding subsidies that pursue a legitimate aim in the sense of common global goods. Also say that we should pragmatically use the possibilities that are on the table, and of course, well, I have to say something, at least a word on the absolute priority of revitalizing the crown jewel of the WTO system. It has to be resuscitated, and the Walker principle, good approach to that, they can perhaps be enriched, provided that we maintain an independent system and maintain this two-step approach.
Thank you. Thank you so much. Thank you. I'm sorry, Wentong and Yaxuan, I only have 1 minute for each of you. Sorry, Wentong, you go first. You're muted, Wentong.
Just quickly respond to a couple questions that I found in the chatter box. I think one question asked about the empirical research that indicates, increasingly larger number of SOEs in China, and that indicate an increase of state capitalism or what. So I don't think we should equate SOEs with state capitalisms. You can have SOEs, but if the SOEs are being operated in fully commercial manners, so it may not be as it may not be the traditional type, the Soviet type SOEs. So we cannot take that for a sole indication that we have state capitalism in China. As I co-authored with Professor Milhout, in 2015, we should move beyond ownership. The ownership of the firm is only one indication, but it's not the sole indication. Also, I think a couple questions asked about our position on the new subsidy proposals, and also whether we should allow stricter or more relaxed use of subsidies under the new subsidy regime. I think our proposal here is more process-oriented than outcome-oriented. We don't take a position in our proposal. What we are saying is, whatever positions the WTO members may come to regarding subsidies, it's more important to have a consensus-driven process where we can achieve that position. So we don't really care for that purpose. We don't really care what eventually we will arrive at as a solution to the subsidy issues. We care more about the consensus building process. So I can turn to Yaxuan. I know I have.
Thank you so much, Yaxuan.
Thank you. So just wrap up, also like to actually cover the aspect about new transparency challenges. I wanted to say at the beginning, no matter how much we use, for example, technologies or new ways of using technology to fix the current transparency mechanism, it might be just like using a 3-dimension to fix a problem in a 2-dimensional world. What I see in terms of the new transparency challenges is really about we are facing a world that constantly require quality and quantity and speed requirements of trade information and trade policy information in a way that's completely different from the last century. So there is a necessity to make the multilateral trading system relevant to reality. What we have sufficient technology readiness to transform how data for trade policies get captured, processed, and aggregated for the deliberation. But WTO has the convening power to host the innovations of a supply chain monitoring and to generate a network effect to incentivize public and private data sharing, exploring automated and real-time dispute resolutions for trade problems on the spot, and then having digital platforms that can aggregate trade problems and build connections with national trade policies are actually really needed for the expedient deliberation and resolution. Trade and negotiations moving forward need to have concrete obligations of inclusion to address the problem of digital gap. WTO as an institution and guardians of world trade data needs to digitally transform itself into a data-driven organization as well. Investment and technology adoption at this global infrastructure level would also help to address the capacity challenges of developing countries. The paradigm shift towards would have implication also on the substantive rules of international trade. The inclusion of, for example, supply chain transparency to the extent that the process and production methods are fully traceable would open the door for actively including non-trade considerations. Overall, we have less than 10 years for the achievement of 2030 SDGs. Tools are available. It's just a matter of choice. Thank you.
Thank you so much. We have so many new ideas and so many new perspectives to address the traditional or new or emerging issues. The only regret that I have is we do not have enough time to continue any further. So let me conclude by saying that I appreciate so much for our panelists, our speakers, being contributing so much in this in the discussion, in the interaction, and I believe our audience share with me that we learn so much from all of you. Let me say thank you so much for your speeches and your papers. And perhaps we need to conclude our session. Thank you. Thank you. Thank you so much. Bye-bye.
Thanks a lot.
Thank you.
Bye-bye.